So next week, the Supreme Court will reconsider challenges which will strike down assault weapon and magazine bans nationwide. So let's break down what is happening. Now, really quick before I jump into this video, I want to ask you guys for a huge favor. Looking at some of my analytics, about 58 to 60% of all viewers are actually not subscribed to the channel. So if you want to support, please consider subscribing. Also, just dropping a comment down below, something positive, just saying you enjoy this video, helps to tell the algorithm that it should send it to more people and spread this type of two-way information. As I mentioned in the intro, in this video, we need to talk about some very important developments in a couple cases which are challenging various state bans on so-called assault weapons and also magazine restrictions as well. These critical cases we're going to be breaking down, we've talked about before. It's the Snope versus Brown case, and then also Ocean State Tactical. These two cases we've been keeping our eyes on because the Supreme Court recently relisted them multiple times for conference, and we were hoping that the Supreme Court would actually grant review to at least one of these during their last consideration of these cases. Unfortunately, the Supreme Court did not do that. However, not all hope is lost. Even though they're not going to consider it this term, they still have relisted these for conference next week. So next Friday, they're going to reconsider these, and there is still hope that they would grant review to these cases. So we need to talk about what is going on and what happens now going forward, and what's the outlook of these cases. Now, for those not aware, the Snope case is kind of the biggest case out of the two because it deals with a state's ban on so-called assault weapons, which has prior been GVR'd actually by the Supreme Court after Bruin. So this case is something the Supreme Court is familiar with, and they've GVR'd this case before. This case involves the state of Maryland defining certain firearms as so-called assault weapons and therefore restricting their purchase and possession. This ban was challenged in a Maryland federal district court. However, the case was then dismissed by the lower court because they already had a case on the books, some precedent that already found that the Maryland ban here on rifles did not violate the Second Amendment. That prior case was called Colby, and it was ruled on by the Fourth Circuit en banc panel prior, but using the old two-step approach. This case, Snope conceded that Colby was the controlling precedent in the Fourth Circuit at that time, but they argued the dismissal of this case was improper and that prior analysis was also incorrect, and they did not look at the Second Amendment analysis correctly. The dismissal of this case was then appealed to the Fourth Circuit, and the Fourth Circuit once again upheld that dismissal. Then the case went to the Supreme Court back in 2022, seeking review of this issue. At that time, the Supreme Court ruled in the landmark Second Amendment case Bruin, and the Bianchi case here, which is now Snope, was then GVR'd back down to the Fourth Circuit for a new decision in light of Bruin. This case was then opened back up in the Fourth Circuit, and the court held oral arguments back in December of 2022. But then after that time, what ended up happening is this case sat for 13 months, and then suddenly the Fourth Circuit en banc panel decided that they wanted to take control of this case once again. They took it out of the hands of that three-judge panel, review, and they said that they wanted to rule on this on their own. Now, after review, the Fourth Circuit en banc panel issued their decision upholding the Maryland rifle ban even under Bruin. Now, in that decision, the Fourth Circuit upheld the state's ban using the incorrect military use test. Essentially, the Fourth Circuit en banc panel believed that AR-15s are useful in military service and therefore could be outright banned by a state. As a result of that, this horrible decision has now made its way back to Supreme Court, and here the plaintiffs are seeking Supreme Court review, and ultimately they want this state law to be struck down. The Snope case was originally set for Supreme Court conference back in December 13th of 2024, but then the court preemptively rescheduled the case, and then it was set for conference on January 10th. It was then relisted for January 17th conference, and then once again for January 24th. Now, the most recent event in these cases is that there was no notice on the order list after January 24th, and so we knew that this case was going to be kind of in a holding pattern and that the Supreme Court was not going to take it this term. They were not going to decide it this term, and it was looking like they were at least going to push it out into next term. Now, recently we got an update on the docket in this case, and the Supreme Court has set this for the next calendar conference, which is February 21st, which is what I said would happen, and that's exactly what the court did. Now, the other case is Ocean State Tactical, and in that case, the plaintiffs challenged the state of Rhode Island's ban on magazines, essentially the restrictions where you cannot have more than 10 rounds in a magazine. In that case, there was a denial of a preliminary injunction against the state of Rhode Island's restrictions on magazines. And unlike the Snope case, the Rhode Island case here is still in an interlocutory posture, but it still deals with a magazine restriction and a denial of a preliminary injunction. The Ocean State tactical case has been trailing with Snope, and ultimately it was also relisted for the next conference, which is going to be February 21st. Now, you may be asking yourself, why is the Supreme Court relisting these cases so many times? Why is a relist so important? Well, that's because all Supreme Court analytics in the tracking of data of prior cases shows that a case has a higher odds of being granted review by the Supreme Court if it's relisted only one time. In fact, according to the data for the court's 2016 to 2020 terms, between 31% and 43% of all petitions that were relisted at least once were eventually granted review by the Supreme Court. So the data shows that at least relisting a case one time has a higher odds of actually getting Supreme Court review. But the data also shows that multiple relist is likely not a great thing. Sometimes when there are multiple relists, it could be a bad sign for a case. The data shows that a case becomes less likely to be granted review by the Supreme Court if it's relisted more than 2 times. And then the more times it's relisted, the chances drop more and more for it to actually be granted review. Multiple relists often indicates that the case is going to be denied review by the Supreme Court, and potentially there's going to be some sort of dissent on the denial. We see that happening quite often. For example, Justice Thomas often writes dissents in some denials of very high profile Second Amendment cases that were denied review. For example, the data shows that in 2022, only 28% of all cases were granted review after 2 relists. And the percentage drops even more, the more times it's relisted, 3 or more times when it's relisted, the odds go down even more. So where does this data and where does the recent developments of the relist next week actually leave these cases? Well, the first domino kind of fell with the Gray versus Jennings case being denied review by the Supreme Court after the January 10th conference. However, since the Supreme Court did not outright deny the Snope and also the Ocean State tactical case, that kind of left everybody with some hope and scratching their head because they kept the Ocean State tactical case, which was also a preliminary injunction review, and they denied the Gray versus Jennings case, which was also a magazine ban, and it was also on a preliminary injunction review. However, now with multiple relists, the odds are kind of moving towards the Supreme Court potentially actually denying review of these cases. The multiple relists could be a product of maybe some dissents being written by justices like Thomas and Alito, who maybe would be unhappy with the denial. Now, this is not to say that that is 100% what is actually going to happen in these cases. There's always an outside chance, and there's always some other cases where multiple relists were actually a product of heightened interest in the case, or simply that the Supreme Court wanted to push the case out to a later review. For example, when you look at the most recent landmark Second Amendment case, New York State Rifle and Pistol Association versus Bruin, that case was relisted for conference 4 times before it was actually granted review by the Supreme Court. And then also you had the Cargill bump stock challenge that was also relisted 4 times before it was granted review. So if you're looking at some of the other Second Amendment cases that have faced multiple relists, you could see a kind of thread where they're relisted, 4 times, even sometimes more, and still granted review by the Supreme Court. So anyone saying that the cases are 100% done because they've been relisted, multiple times, they're just not looking at the data and the history for prior Second Amendment cases that were granted review even after they were relisted, 4+ times. So not the most ideal situation, but not all hope is lost with these cases. The ultimate goal is for the Supreme Court to grant review to these cases. That's what we want. And they are still alive and they're still going to conference next week. Now, if you were to ask me, my gut is telling me and maybe even preparing me for these cases being denied review by the Supreme Court and maybe some dissents being written, but ultimately my heart wants these cases to be granted review. I would love to see Bruin applied to these cases, to these types of statewide bans on rifles and magazines. And also I'm kind of holding out hope because we've seen Bruin be relisted multiple times, 4 times before being granted review. And then also Cargill was the same way. So my hope is maybe that's also what the Supreme Court is doing here with these cases. So these cases are now entering a very critical stage. All eyes will be on the Supreme Court and what they do after the next Friday conference. We will still have our fingers crossed that maybe they would grant review to at least one of these cases. Typically what happens after the next Friday's conference, the following Monday, you would look at the order list. And if these cases are not on the order list, they're likely going to be relisted again. And if they are on the order list, you're going to be looking for either a grant of review or a denial of these cases. So some very important battles are now coming up in the following weeks that we're going to be tracking. If we get any more information, if anything else develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. it triggers the algorithm and lets it know that it should send this type of two-way information out to more people. Don't forget to comment on this video and share it to other people who you think would find this video helpful. And as always, thank you guys for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by ARM scholars, and this nation will be maintained by ARM scholars.